There are 5 basic types of disciplinary actions. The first, that is the least severe, is an oral admonishment. And an oral admonishment is much like a counseling session. They really don't differ tremendously. But a counseling is considered non-disciplinary, and it's intended to provide guidance and direction, clarify rules and expectations, if you will. But an oral admonishment is actually a disciplinary action. Even though it's called an oral admonishment, it is often documented in writing. You may have a set format that your personnel office would provide to you to actually document that the oral admonishment occurred, what was discussed, what the concern was, and what the corrective action is, meaning expected future behavior if that incident were to occur again. So it is oral, but it needs to be documented accordingly in the supervisor's work folder that an oral admonishment was issued. And again, there's a few of those very basic specifics. It doesn't need to be a long and arduous, detailed document, but you want to have something that is able to be looked back at for clarification and for guidance if, in fact, misconduct repeats itself. It is very guiding and oftentimes can be effective. The next form of disciplinary action is a reprimand, letter of reprimand. It is the least severe actual formal disciplinary action. So although an oral admonishment is discipline, it's not considered formal discipline. A reprimand is an action that is temporary in nature. It is filed in an employee's official personnel file for a period of 2 years. Some labor contracts may call for a lesser period of time, so you want to make sure you're aware of your local agreements. But the point is it's a temporary action intended to correct behavior and can be very effective. The first type of adverse action in the disciplinary action process is a suspension, where you actually have a period of non-duty and non-pay time. You send the employee home without pay. And that can range for a day, or it can actually range up to 30 days. Typically speaking, the Air Force doesn't have supervisors or doesn't recommend supervisors to suspend anyone over 30 days. If you're thinking about the severity of the incident and want to consider something more than 30 days, more often than not, you should just be considering removal at that point. But a suspension, again, it ranges anywhere from 1 to 30 days. If you have a suspension of less than 14 days, then an employee's appeal rights vary than they do if the suspension is 15 or greater days. 15 or greater days, employees have the right to appeal to the Merit Systems Protection Board, so you have a much more formal third-party process. Of course, if you have bargaining unit employees, they could go to grievance and arbitration on regardless of the number of days of suspension. But employees can't do both from that appeal process. Suspensions encompass consistent and concurrent calendar days, 5 days, 3 days, however the case may be. They can carry over on a weekend. And in some cases where you're dealing with alternative forms of discipline, you may want to do a 3-day suspension. It starts on a Friday and ends on a Sunday. So you minimize the actual loss of pay, but yet you still have a suspension on the books. But it's imperative that understand that it's a non-duty, non-pay time. It's amazing the number of employees or supervisors that they can still come to work, but I'm just not going to pay them. Well, obviously not. It's non-duty and non-pay. It is rather severe. It's adverse because it takes away pay. And it's not something that typically is used on a first offense of misconduct. But depending on the serious nature of the incident, by all means, it may very well be appropriate. Demotion is a type of disciplinary and adverse action. It's not very commonly used. But when it is used, it typically has occurred when you have supervisors that are committing misconduct that relate to their supervisory responsibilities. And it's limited in its availability because you must have a vacant position available within the organization to which to demote them. And so it's not very common that occurs, but they do occur. It's not very common necessarily for a regular worker that's non-supervisory, but they could occur. So just need to be aware of the availability of that for the considerations to be given toward that. And then last and most severe is a removal. It is the most severe offense. It typically is not a first offense type action, but if the offense is incredibly egregious, by all means, it may very well be appropriate. And because discipline is intended to be rehabilitative, that the intent is to correct behavior and have a productive and compliant employee. A lot of supervisors and others will think, well, how can removal on a first offense be rehabilitative? It can very well be. It may be just for the next employer. But there are situations in which removal can be appropriate for a first offense. And removal is the one action that has a specific notice period. If you're going to propose a removal, an employee is entitled to a 30-day notice period. So what that means is from the time that the proposed notice is issued to the employee, the decision cannot be effective any earlier than 30 days from when the proposal was issued. And there is one exception to that, and the exception is that the crime provision is what it's commonly called. And that shortens the notice period from 30 days down to 7 days. And that occurs when there is a reason to believe that an employee has committed a crime for which a sentence of imprisonment of 1 year or more is likely. You don't have to have been convicted, and there just has to be that reasonable belief. So an arrest for certain types of offenses would allow you to invoke the crime provision and shorten the notice period from 30 days to 7. It's not common that that occurs, and when it does, and when you're considering that, you and the personnel office will be consulting with the legal office, because they're the ones that are going to look to determine what is the crime, what are the possible sentences for that. And so that's not something that is taken very often, but in very serious offenses, by all means, it shortens that notice period. Okay? There's a couple of times I mentioned previously in talking about the types, there's a very specific due process that has to occur, notwithstanding the oral admonishment, but for each of the others. There has to be a proposal that is issued to the employee. I propose to reprimand you for whatever reason because of whatever has happened, or I propose to suspend you. They are entitled to a proposal. The proposal must be in writing with the exception of a reprimand. A proposal for a reprimand can be done orally. So that's the very first part of it. The next part is the employee is entitled to provide a reply. So when the proposal is issued, it includes language, or orally is conveyed, that you have an opportunity to reply. In some actions, the reply goes to the same proposing official. The same first level supervisor may be the proposing and the deciding official. That commonly happens just with reprimands. But if you're dealing with an actual adverse action, Air Force expects that you use multiple levels of supervision. So for example, the supervisor would be the proposing official, and the second level supervisor would be the deciding official. And in those situations, the employee's reply would go to the second level supervisor. So that's the second part of the due process. There's the proposal, and then there's the reply that the employee is entitled to give. They can give that reply orally, they can give that reply in writing, or they can do both. And they have very specific time frames that you should provide in the notice that give them to give that reply. And then the final part of the due process is the decision. Every action requires a written decision to the employee. And adverse actions, as I mentioned, should have that higher level supervisor rendering the decision, taking into consideration all sorts of different factors, but nothing different than what the proposing official considered. For example, you have to consider what the employee provides in their reply. But if you have new information that comes in that further clarifies or even adds, you cannot consider that at the decision phase. If the supervisor proposed to suspend for AWOL of 8 hours, you can't turn around and decide that you want to add the 4 hours that you found out about from a previous time. You are left with what the supervisor has proposed. So you consider what the employee says, but new evidence, if you will, is inappropriate to bring into the picture. So, but anything that's adverse should have that higher level review attached to that, and the higher level looking at and making the decision. Because again, you're affecting someone's pay. This is not something that should occur typically with just one level of supervision. Disciplinary actions are progressive, typically. As I mentioned, if the behavior is incredibly egregious, it may be appropriate to have removal as the first offense type penalty, but that's just not very common. And they're very, very serious actions when that occurs. So, but it's also important to understand that while actions are progressive, it's not a situation whereas you have to take every single one on your way to removal. So as a sports fan, I commonly say, in this situation, I don't have to touch first to go to second, and I don't have to touch second to go to third, and I don't have to touch third to go home. And what I mean by that is I don't have to do a reprimand before I do a suspension. And I don't have to do a 5-day suspension before I do a 15-day suspension. And I don't have to do a 15-day or a 30-day before I do a removal. There may be situations, you typically should start out with the least severe, appropriate to get the corrective action. But you may, in some situations, advance from a reprimand to a suspension, or you may start with a suspension. Or you may only go from a suspension as the first to a removal on the second offense. So it's typically progressive, but it's not an absolute, you have to touch every single one on your way to get to removal. And it's important to understand that. The key to all actions, the supervisor needs to gather all the facts first. Gather the facts. Don't presume that you know what you think you know, because you oftentimes don't. It is amazing how often the situation and the information changes from the first phone call to my office to the actual bringing in the documents and getting ready to take the action. It is amazing. So don't presume to know, gather the facts, and then sit down and try to come to a conclusion as to what action you need to take.